Hello, I'm David Hardesty. In this lecture, we examine the U.S. tax rules for the classification of an entity as a foreign entity or a domestic entity. Classification as domestic or foreign can have a dramatic impact on an entity's tax liability in the United States. Here are the objectives of this lecture. The objectives of this lecture are to understand when the following entities are classified as domestic or foreign: corporations, partnerships, trusts, and estates. And we want to understand the impact of U.S. tax treaties on the classification of these entities. First, let's recap the primary ways in which classification affects U.S. tax liability. Like U.S. citizens and resident individuals, U.S. domestic corporations, trusts, and estates are taxed in the United States on worldwide income. In addition, when these entities are classified as foreign, they are taxed in the United States only on effectively connected income and U.S. source non-business income. Note that these rules apply only to the entities themselves. When income is passed through to owners or beneficiaries, then taxation in the United States depends on the status of those owners or beneficiaries as resident or non-resident individuals, U.S. citizens, or foreign or domestic entities. Let's begin with classification of a corporation as either domestic or foreign under U.S. domestic tax law. A corporation is domestic if it is organized under the laws of the United States in one of the states or the District of Columbia. As an exception, a domestic corporation can elect to have a 100% owned Canadian or Mexican subsidiary corporation treated as a domestic corporation, but only if the subsidiary is organized and maintained solely for the purpose of complying with the laws of Canada or Mexico as to the title and operation of property. Corporations that are not classified as domestic are automatically classified as foreign. Classification is not affected by whether shareholders are foreign or domestic entities or resident or non-resident individuals. The term corporation is not defined in the tax code, but it is defined in the regulations at Regulation 301.7701-1 through 7701-3. Here is an example of the classification of a corporation as foreign. Foreign Co. plc is a Hong Kong Public Limited Company, or PLC. Some of its owners are Hong Kong citizens and some are U.S. citizens. Under the regulations at 301.7701-2B8, a Hong Kong PLC is considered a corporation for U.S. tax purposes. Because Foreign Co. is not organized in the United States, it is considered to be a foreign corporation. How is the classification of a corporation affected by U.S. tax treaties? U.S. tax treaties do not impact the classification of corporations as domestic or foreign. Instead, they deal only with whether a corporation is a resident of one of the treaty countries. The U.S. Model Income Tax Convention at Article 4.1 provides that the term resident of a contracting state means any person who, under the laws of that state, is liable to tax therein by reason of its domicile, residence, citizenship, place of management, or place of incorporation. This rule makes it possible for a U.S. domestic corporation to be a resident of a foreign country if the corporation is managed in that country. However, it does not make it possible for a foreign corporation to be treated as a U.S. resident because under U.S. domestic tax law, U.S. tax liability is not based on place of management. Note, however, that U.S. tax treaties at Article 4.4 provide that where a corporation is a resident of two countries, such as where a U.S. corporation is a resident of a country based on management in that country, then residency for treaty purposes is assigned to the country in which the corporation is organized. Thus, a U.S. corporation will always be a U.S. resident for treaty purposes. Here's an example of a treaty classification of a corporation. Foreign Co. is a country X corporation that is effectively managed in the United States. Under the domestic laws of country X, Foreign Co. is considered a resident of the United States because its management is there. However, under the U.S. country X treaty, place of organization takes precedence over place of management. In addition, under U.S. laws, Foreign Co. is a foreign corporation because it is not organized in the United States. Accordingly, Foreign Co. is a foreign corporation that is a resident of country X. What about the classification of a partnership under U.S. domestic tax law? A partnership is domestic if it is organized under the laws of the United States in one of the states or the District of Columbia, unless the regulations provide otherwise. A partnership is classified as foreign if it is not created or organized in the United States, or if it is classified as foreign under IRS regulations. The status of partners as either resident or non-resident individuals, U.S. citizens, or foreign or domestic entities does not affect the classification of the partnership itself. Here's an example of the classification of a partnership. Partnership X is organized under the laws of California, but all of its partners are foreign citizens and residents. Partnership X will be considered domestic, not foreign, because it is organized in the United States. The classification of a partnership is not directly affected by tax treaties. A tax treaty does not affect whether a partnership is domestic or foreign. Moreover, a partnership generally cannot be a resident of a country for treaty purposes because it is not liable for tax in a country by reason of its place of management. Instead, the U.S. Model Treaty at Article 1.6 provides that each item of income is considered to be derived by a resident of a particular state to the extent that the item is taxed to a resident of that state under the tax laws of that state. That is, tax treaties look through the partnership and treat each item of income as being derived by a resident or a non-resident based on the status of the partner who recognizes the income. Here's an example of this concept. Jones is a partner in Foreign Co., which is a Country X partnership by virtue of its being organized in Country X. The management of Foreign Co. is also in Country X. Jones, however, is a U.S. citizen and resident, and is taxable in the United States on his distributive share of Foreign Co. income. In addition, he's treated under the U.S. Country X Treaty as a resident of the United States. Accordingly, under the treaty, his distributive share of the partnership income is considered to be the income of a resident of the United States. Now let us turn to the classification of a trust under U.S. domestic tax law. A trust will be considered to be classified as foreign if it is not classified as domestic. To be classified as domestic, a trust must meet two tests. The first is the court test, under which, to be classified as domestic, a trust must be subject to the primary supervision of a U.S. court. This does not mean other courts in other countries cannot have jurisdiction over the trust. However, a U.S. court must have the responsibility for primary supervision. The second test is the control test, under which U.S. persons must have the authority to control all substantial decisions of the trust. Other foreign persons can have some decision-making authority, but the primary authority to make decisions affecting the trust, its assets, or transactions with its beneficiaries must lodge with U.S. persons. Here's an example of the classification of a trust. Adams, a United States citizen, creates a trust for the equal benefit of his two children, both of whom are United States citizens. The trust instrument provides that Domestic Co., a domestic corporation, is to act as trustee of the trust, and that the trust is to be administered in Country X, a foreign country. Domestic Co. maintains a foreign branch in that country, with personnel authorized to act as trustees in Country X. This example is continued on the next slide. The trust instrument provides that the laws of Delaware are to govern the interpretation of the trust. Under the law of Country X, a court within Country X is able to exercise primary supervision over the administration of the trust. Pursuant to the trust instrument, the Country X court applies the law of Delaware to the trust. Under the terms of the trust instrument, the trust is administered in Country X. No court within the United States is able to exercise primary supervision over the administration of the trust. The trust fails to satisfy the court test and is therefore a foreign trust. Finally, let us turn to the classification of an estate under U.S. domestic tax law. Under the Code, An estate is foreign if it is not subject to U.S. income tax on income that is neither effectively connected nor foreign source income. That is, an estate is considered foreign if it is taxed as a non-resident alien. This definition seems a bit circular, so let us put it aside and turn to other guidance. In the absence of a workable rule in a code, we turn to judicial theory. As discussed in the text, an estate should be considered domestic only if its physical connections with the United States predominate over those with foreign countries, and should be considered foreign if its foreign connections predominate. Here's an example of the classification of an estate. The Jones estate was created in England. 90% of its assets were invested in the stocks and securities of U.S. corporations. 3 of its trustees were English, and 1 was a U.S. citizen. The estate maintained a New York office from which the American trustee managed day-to-day investment activities. Major investment decisions regarding the estate were made by the American trustee and one of the English trustees, who made semi-annual trips to New York for this purpose. This example is continued on the next slide. The estate was governed by English law. In a trust case involving these same facts, the trust was deemed a U.S. resident because its physical connections with the United States predominated over its foreign connections. Based on this analysis, and absent other statutory or regulatory guidance, the estate, in this case, in the case we're considering the Jones estate, would be considered a U.S. resident.